Here we go. Folks, the moment of truth. The judge wants to hear their side. Notice how fast we've jumped straight into numbers? That's typical in housing court. The rent math always sets the stage for the drama.
And Mr. Friedman, how much is owing?
2630 rent, 275 in cost, 2905.
2905. All right, folks, what do you have to say about that?
They just entered that price yesterday. That's not what we were supposed to pay. They just entered that yesterday.
And here comes the dispute. Damages versus rent. Classic confusion. Quick legal insight. Normally, rent claims and damage claims are handled separately. Mixing them muddies the waters, and that's exactly what's happening here.
I thought it was $1,500 left over of what I was prepared to. We were supposed to pay. DHS was supposed to pay amount, and then I had $1,000 left over. So yesterday they added all that on there.
What do you mean they added all that on there?
That's after we moved out. They said damages of like trash and things like that, of mail key not being returned and stuff like that.
So you vacated the premises?
Yeah, we are. Our lease ended on the 15th.
All right, so you're no longer in the premises.
Mm-mm.
All right, so the premises have been surrendered. And so you're disputing the money.
Pause for a second. Did you catch what the judge just did? He's not issuing a final judgment today. Instead, he's adjourning for a settlement conference. Translation: one last chance for both sides to bring receipts, ledgers, and proof before the hammer drops. Smart move. It buys everyone time.
Money judgment portion of this.
Yeah.
As the amount that you owe. Mr. Friedman, do you know anything about the adding of anything?
No, this is the rent and only rent. I think she must be talking about security deposit situation, but this amount does not have anything to do with damages to the unit.
Ask them, how do we owe that amount then? Because we paid $1,200, and when he adjourned it that week when we was here last time, we paid $1,200.
You paid $1,200 since then?
In July, we finished the $1,200.
Well, in August, what did you pay?
I didn't know we had to pay because we were moving out the end of the lease. They informed me this week that it's not prorated because it's student housing, and so we owed August rent. So that would be $1,095. So altogether, it would have been the $1,500 of what we owed left. That's why I'm confused on how it's $2,000 now.
On what?
On how he said we owe $2,000 now. It was only $1,500 on the portal that they said that we owed. We only owed August rent because July.
I have never had $1,500. You owed $1,700 in July.
I paid $1,200.
When did you pay the $1,200?
Before we came back. I can show my portal.
All right. So let me just do this here real quick. And how much was your monthly rent? $1,095?
Yes.
All right. So even if I just ballpark these numbers, but you owe $1,100 for then August, right?
Yes.
And then there's going to be court costs, plus you would have had a $540 balance.
And then I gave them a check on the Friday that they adjourned court of $300.
This is only about the money judgment portion. What I'm going to do is I will adjourn this basically for a final settlement conference to what's my next.
Notice how the judge is double-checking the tenant's plan to cover rent with outside assistance. This is huge. Programs like these can literally keep someone from losing their home. But the judge has to balance compassion with procedure, and that's why he locks in the possession judgment with conditions.
Next day to September 16th, 2025. That's in person. You bring proof of your payment, they'll bring us a ledger, and then I'll take a look at it and we'll make a decision.
Thank you.
All right.
What time is that, Your Honor?
9 a.m.
9 a.m. Thank you. Have a good holiday.
Thank you. Okay, you too, sir. River Ridge versus Kaylee Hamill. Uh-oh. Did I get that right?
You did.
Okay. I got it right, and I'd love to take credit for it. I really would. I would love to take credit. But somebody on the outside of the file scratched off the other name. So it was the only thing I could call. All right.
Thank you.
You did that?
I did.
Did you? All right. All right. And where are we on this case?
Good afternoon, Your Honor. Casey Matson at P87729 on behalf of plaintiff.
Good afternoon.
Your Honor, we show a balance remaining. The rent to retain is $1,573.00. Cost of $175.00 for a total of $1,748.00.
Okay.
Is that
So there was about $1,000 payment made?
well the 1780 that I had with you guys? That was in
Hang on.
escrow.
Hang on.
Escrow, yes.
And that may be. Have you received that?
Your Honor, I believe so. That I believe was applied to the balance on the 18th, which would have been shortly after the hearing.
And that was 1780 total?
Correct.
Okay, so that was our escrow.
Right. So does that the cost that you just stated is that with September?
I see what you're getting at. Because last hearing when we were here, the number I was given was 2885, and that was on the 15th of August. And so then you would have received the 1780, which should have put us around 1,000.
Right.
Yes, Your Honor, I do see it. I read off what was the previous judgment amount. So the total balance now is $1,155.
1,155. That sounds more like it.
Yes.
Okay.
So I spoke with the gentleman from the Breeze program at Michigan Works. I can pick up the check on Tuesday because of course everything's closed Monday. And it's 2 months worth of rent, so it would cover that plus some.
Gotcha.
But I can't pick it up until Tuesday. But in full transparency, I have a clinical rotation from 7 a.m. to 7 p.m. that day, and I don't think they'll be open after. So I can pick it up Wednesday, and it will be dropped off before 5 p.m.
Okay, and some of that money is going to go towards your September rent, right?
Like $75, but I will pay the rest of it the same day, like the rest of September rent. Does that make sense?
No. But I think I get you. You're going to bring that check from that program.
Right.
Plus you have additional funds that you're going to apply.
Yes.
Okay, so here's what I'm going to do so that we can do it this way. I'm going to grant a judgment for possession, and I'll explain why I'm going to do that. Grant a judgment for possession for that amount of the 1155. All right.
Mm-hmm.
That's finding no tribal issue after hearing. And with a writ date of September 8th, which would be the statutory period. So basically what I've done is I've locked the August thing, not including anything regarding September.
Okay.
You just need to pay this 1155. That gets rid of this case. And then you're just paying September.
What's the 8th? Okay. Yeah, that's fine. I didn't know.
So you were talking next week, which was going to be like the second, third.
Right. Yes.
But you get a 10-day period to do it. You do it this way.
Perfect.
All right. That
Thank
works.
you.
All right, Miss Hamill. You take care. Have a wonderful holiday.
Thank you, Your Honor.
Sile Farms versus Frank Loy.
PC Matson, P87729 on behalf of plaintiff.
Whoa, demolition order granted. Yes, you heard that right. When tenants abandon manufactured homes and rent isn't paid, landlords can actually petition the court to demolish the unit. It's rare, it's final, and it's a brutal endgame.
Excuse me?
Mr. Lloyd is not present, and this is a motion.
It's a motion to demolish the mobile home. Is that correct, counsel?
Yes, Your Honor, this is a motion to demo the manufactured home on site. There was a previous default judgment awarded in this case and subsequent order of eviction, which was executed. Defendant hasn't made any contact with any intentions to remove or sell the home, and the rental balance has not been paid.
Defendant having failed to appear and having heard the merits of plaintiff's motion, the motion to demolish home is granted. And I will sign that order.
See what the judge is doing here? Extending the eviction date. This is subtle but powerful. It gives the tenant one last window to pull funds together. But here's the kicker. If she doesn't pay, the debt only grows. It's a ticking time bomb.
Thank you, Your Honor. Did you have a proposed order in your file?
Absolutely.
Thank
You guys
you.
are always very good about that. All right. Thank you. Sile Farms versus Antoine Bailey. There he is.
That's on behalf of plaintiff.
Your name?
Antoine Bailey.
Okay. And what do you have as his balance?
1277.
We have the total balance, including the court costs, is $1,277.68.
All right. How are you gonna get that paid, young man?
I have it taken care of. She know what I have to do.
I'm sorry?
I have it taken care of. We agreed that I have it paid by the 8th.
By the 8th?
Correct.
All right, so then what I'm gonna do then is I'm going to I'm gonna grant a judgment for possession, finding no tribal issue after a hearing for the total amount of the $1,277.68 with a writ date after the 8th or the 8th thereafter. All right? Okay.
Can I get a copy of that?
Pardon?
Can I get a copy of that?
The judgment will come through. You can get a copy of it on Tuesday.
All right. Thanks, man.
Okay?
Appreciate it.
Thank you.
All right.
Take care.
Thank
So your belief that they may be willing to work out something with her? Or
We don't do a long-term payment plan, Your Honor.
Pardon?
We normally don't do long-term payment plans, and so she's going to be at 3927.18. We come back next month. There's an extra $1,200 she has to get.
Well, to my knowledge, I had spoke with the account manager at Evergreen. She told me that my September rent was already added on there. So it's probably already at the 3,900 something, to my knowledge.
But not, right, that it may have been added on, but not in the figure that I was given.
Right.
Yeah.
It's
Right.
on her ledger, but it's not part of
Part of what they,
Yeah.
the number that you.
So she'll be at 3927 next week.
All right. Here's what I'm going to do, young lady. I'm going to find that there's no tribal issue after a hearing in this matter. I'm going to grant them a judgment, and I'll explain why.
Okay.
Judgment for possession for the amount of $27,5074. I will extend the order of eviction date out a week, so it would be September 15th.
Okay.
All right. Try to give you time to try to figure out how you're going to come up with this. If I adjourn it out, I'm going to be about the same spot, but it's going to be a higher number.
Okay.
So if you can get this number, then that can save your tenancy, and then you need to work towards September. So,
Okay. All right.
got it?
That's fine.
You,
Yep.
you understand what I'm doing?
Mm-hmm.
Okay. And ma'am, you understand why your case got called first, right?
I'm assuming it's because I was here early.
That,
Yeah,
and
I was here
I
for
will
hours.
just tell you, they they let me know that you were here early, and they said she has been out there. They told her she could walk around, she could do whatever she wanted to do. And oh, by the way, Judge, I think she's pregnant. And so
I am.
so
Me too.
that's why I called yours first too, Mr. Fink. All right, that's why part of the reason we got you out of here. They were
Okay.
they were yelling at me back there. I don't know. It was horrible.
Okay, no,
All right.
thank you.
You have a great weekend, young lady. Court calls case of Avalon Housing versus Alicia Tate.
Good afternoon, Your Honor. Jill Bauer here on behalf of this case is also present.
Do you think the plaintiff?
Your Honor, myself and Ms. Engen have really tried to resolve this case, but we discovered it's a recertification issue. I have a FOIA into MSHA. Unfortunately, RPI was not able to provide me with any documents, but I also made an RA request this week, and those tend to move a lot faster. So we just need a little time to figure this out. And then once we can determine if her rent was properly calculated, I do have applications in for her with Emergency Housing Fund already. They're just waiting for the right number to finish processing it.
All right. Is that your understanding, sir?
Your Honor, I never dealt what Ms. Bauer says in terms of the facts. And we are willing to do a COD, but I don't see any reason not to adjourn it for a couple of weeks to see if she can make progress before we do that.
All right.
And if nothing else, we can come up with a COD that.
Yeah, Ms. Engen and I we are really communicating frequently on this one and trying to figure it out. Your Honor, I'm going to be out of the country in 2 weeks, so if we could go 3 weeks, I would appreciate it.
The 19th.
That works for me.
It'll work on this Avalon case, Your Honor.
All right. September 19, 2025, 2 p.m.
Thank you.
All right. Thank you.
You're welcome, Ms. T.
Avalon Housing versus Vicki Bennett. And Crossing 2 versus Durban Weatherspoon.
Adjourn again. Notice a pattern? Housing court is less about dramatic guilty or not guilty moments and more about buying time. Every adjournment is another shot at paperwork, funding, or negotiation. But eventually, the clock runs out.
James Sink for the plaintiff.
Your Honor, Jill Bauer on behalf of Ms. Weatherspoon, we have excellent news to report to the court. We have received funding for 100%. I have commitment letters from 2 funders, and so we're just waiting for those funds to be sent to the plaintiff.
Has that information been sent to the plaintiff? Or...
There you are.
No, it's okay.
Kind of multitask for these days.
I will tell you, Your Honor, while Mr. Fink is looking, we discussed a 3-week adjournment, and we think that the case will be dismissed before that because the funds will probably be received.
Her facts are generally correct, but not always complete. She was discussing the 3-week adjournment. I was talking about 2. And
well, I would say if
yeah.
you have the commitment letters, the motion that you sent in indicated that the balance could be cleared in 2 weeks. So.
Thank you, Your Honor.
Adjourn this matter to September 12th, 2025.
Your Honor, I'm going to be in Europe on that date.
Everybody in your office will be in Europe?
Well, Your Honor, we're very short-handed right
No,
now.
you're
Your Honor, we have a.
No, you're not. The
I don't know
legal
what she's worried
services,
about.
they're all over the place.
And Ms. Weatherspoon is an Ypsilanti Weatherspoon. I don't think anybody thinks I'm going to do something untoward to her.
And me either, so. Yeah. I'm gonna set it on the 12th at 1 p.m.
Yes.
See if we get taken care of. All right, you take care. Have a good weekend. Hamilton Crossing 1 versus Keisha Franklin.
Jill Bauer on behalf of Ms. Franklin, Your Honor, who is also present.
right? Where are we on this?
Your Honor, we're still trying to schedule an inspection of the stove. We think that the information from the inspection could be very helpful in settling the case. So we're asking for another adjournment until that can take place.
Who's going to inspect the stove?
We found an electrician who's willing to do it on behalf of Miss Franklin.
So when's that going to happen?
Well, we reported that back to the court last time we were here, and we have been trying to get a date and time to inspect the stove, and we just haven't been provided with one yet.
Can we just set it for a trial and hopefully the rest of the stuff will be done by then?
Final settlement conference, September 16th, 2025, 9 a.m. That's in.
Your Honor, I'm going to be in Europe on that day, and I really am the person that needs to be here for that hearing.
They're called summary proceedings, Your Honor.
No, I'm not going all the way to the end of the month. This was supposed to, the last adjournment we were here, they were supposed to, what's the hold up on the inspection? Yes, ma'am.
I called and asked them where was the stove. They had no idea. And they said, I asked them why they didn't give my lawyer a date, and they didn't have no idea either. And they knew that last time we went. That's why we adjourned it to now.
So somebody's got to find this stove to inspect?
They should have it.
Oh my gosh, you can't make this stuff up. All right, I'll make it the 19th. And
Still a final settlement conference?
no, it's gonna have to, I'm gonna put it on this docket, but I can give a quick final settlement conference if we don't have things going.
Okay.
September 19th, 2025, 2 p.m.
Thank you, Your Honor.
Thank you.
Oh, and Your Honor, just for the record, I'm sorry, Miss Franklin paid her escrow. She wanted you to know that.
Oh, thank you.
So I still come and put it in for this month coming?
Yes, ma'am.
Yeah, can you tell me how much is in escrow?
It was ordered that she pay $55.
Yeah.
The receipt shows
And then you
$55.
still get on the first?
She's gonna
Yes.
pay 110 next week, probably the second, because the first is off.
That makes sense.
Yeah. Hamilton Crossing 1 versus Kristen Benson. What's your name?
Kristen Vincent.
All right. And what is plaintiff's claim in this case? Well, he looks for the number. Did you get the 1,000 paid?
So no, I got a call from Miss Ballard last week, and she gave me a different amount that was owed, which was $1,862. So I did get notified from Friends Indeed that they would give me $500, and from Peace Neighborhood Community $500 from them. So that would have been close enough to get to where I was on a payment plan. She sent me a letter they put a letter on my door that following week telling me that I had to pay again $2,301 within 3 days or be out. So I was very confused. I couldn't get in contact with her until just yesterday around 4:30 p.m. when she sent me basically everything, like almost like a ledger of everything that I owed and that the amount is correct. So now I have to basically reapply with the Friends in Need for the amount, because it was a certain amount that I had to get to get the assistance from them. But when she gave me the lower amount, that's what I thought I had to reach. So it was just a mix up, but I did come up with the 500 that was needed. I just haven't been able to drop it off. Just heard from her yesterday, just getting clarification on what was going on.
So you have 500 that you can pay to the landlord?
Yes, right now.
Okay.
My note says she's gonna pay 600 today and then we're gonna work on a COD. So I think a 2-week adjournment makes sense.
Okay.
That work for you, ma'am?
Sure.
September 12th, 2025.
Okay.
1 p.m.
Now, if this is done before then, I don't have to come back.
Well, you want to see me?
Yes.
Do you want to put MCR 4.201J on the record?
I'll put that on there right now. Ma'am, if it ends up in a conditional order of dismissal, from the time that I sign it, you have 3 business days in which to think about that. If you believe that there's some right you didn't assert, some confusion on your part, or some mistake that you've made, you'd have to file a motion with the court within 3 days of my signing that.
Okay.
Okay?
Okay.
Understand that?
Yes.
All right. Fine. You don't want to see me? Bye. No.
Have a good weekend.
You too. Court does call the case of Hamilton Crossing 1 versus Christina Franks Hatter.
James Singh for the plaintiff.
Hello. What's your,
Christina Franks Hatter.
all right.
Her total is 936.
Yeah,
Yes, sir.
that's his father, Tommy Hatter. That's their brothers.
All right. So how are you going to get this paid?
Tanisha granted me the COD from last time on the 15th when I came from Strong Future.
I got a note that says we'll do a COD, so
And so I have $75 on me today from Chase to pay
give
it.
it to me, I'll lose it.
All right.
Address.
You have a COD there?
No, I don't have one, but we'll do one.
Okay. So I'll adjourn this out a couple weeks to the 12th.
email
Let's
address.
give you time to get that in.
Spelling counts.
2025 at 1
It's my
p.m.
first and last name.
Yeah.
iCloud. Just in case you can't.
Do you want to give her 4.201J? Thank you.
So, ma'am, I'm adjourning your case out to the 12th.
Mhm.
There's going to be a COD prepared and be able to look it over and sign it. Okay, I wouldn't sign it if you don't understand it, but I'm going to advise you since there will be basically an order, you're not represented by counsel. You would have 3 business days after my signing to file a motion. If for some reason you believe that there's a right you didn't assert, some confusion on your part or some mistake, you have 3 business days to file a motion or to revisit it or set it aside.
Okay.
You understand that?
Yes.
All right, wonderful. You have a great weekend.
Thank you, you too.